What are the major changes that we're going to be talking about? First one, positive adjustment time, right? PAT, point after touchdown. Yay. Second one, risk reduction sentences, all right? Those are sentences, the positive adjustment time is largely going to be what do people do in prison and how does it affect their release date. Risk reduction sentences is going to be at the point of sentencing. All right, the judge is going to decide for certain people they can serve what they call a risk reduction sentence. There's going to be some changes to bifurcated sentencing modifications and adjustments. And one of these, I think, may end up being the outlet for which the majority of early release offenders end up using. There are going to be changes to the earned release and challenge incarceration program. Those are programs, those were some of the programs under the earlier versions of TIS that allowed people to get out. Boot camp and drug abuse correctional center. There's a second, there's like 2 or 3 boot camps now, and there's more than one drug abuse correctional center that has allowed people to get out early through the earned release program. But the sticking point has been the earned release program was only really designed for drug and alcohol, people with drug and alcohol offenses, and they go through AODA treatment and then get out. And the earned release or the challenge incarceration program was always theoretically you had to have a drug problem that was sort of part of what was driving criminal conduct. That will no longer be true, so you don't have to have the conversation with your clients that says, you use marijuana, right, and it's a problem, right? So you want to be in the challenges. So that's not going to be needed anymore. There's going to be early termination of extended supervision as a possibility, and early discharge from probation as a possibility, 50% in fact on the probation. So that's, and then one thing that I think is going to be huge is no more judges in reincarceration matters. And there's an expansion of expunction. Positive adjustment time. Let's talk about that first. This is going to be allow people to get out of prison to earn early release by not violating prison rules. What is this with the virus thing? Viruses. H1N1 is trying to infect my computer. It's essentially going to be, I mean, you can see from the language, allow people to get out by not violating prison rules and not refusing to perform required or assigned duties. Sound familiar, right? It's the reverse of the bad time that the judges always used to drone on about with our clients, which they also don't have to do anymore. That's another change. They don't have to read that form. So you are going to be able to get out, and when you get out and how you go about getting out is going to depend on the type of sentence you're serving time for. So there's going to be 3 different categories of offenders. All right, and this is all in the outline on the materials, but it's also in various other places that you can look at, including the statutes, which is always a good idea to look at. The first category of offenders and the people who are going to have the easiest time getting released are those people convicted of non-violent Class F through I felonies who are not determined by DOC using a risk assessment instrument, the DOC 502, I think is what it's going to be, what it is, to be at a high risk for reoffending. And it sounds good, but I think that it's going to be a fairly small number of people. I mean, basically, I think what will end up happening is these people will be people who probably aren't going to prison anyway, right? Non-violent Class F through I felonies who are, if you look at a risk assessment instrument with them, they end up being not at a high risk to reoffend. Well, hopefully those people are not ending up in prison in the first place. But in any case, they will have the easiest time getting out. The next category of offenders, I'm just pulling out my chart for F through I felonies. So, a lot of the drug offenders and forgery. I mean, a lot of these are people who are going to be probably not going to prison in the first place. The second class are those who are deemed to be at a high risk to reoffend or violent Class F through I felonies, and they're going to have a different way to try to take advantage of positive adjustment time. And then the third class is going to be C through E felonies who are going to have going to be a little bit, when they can get out is going to be different from Class 2. How they get out will be roughly the same as Class 2. Registered people who are convicted of sex offenses for which they have to register need not apply. Category 1, so we're talking about nonviolent F through Y felonies plus misdemeanors who are in the prison system for habitual misdemeanors. And they're not high risk as determined by a DOC risk assessment instrument. So they can earn essentially a 1/3 cut on their sentence, right? 1 day for every 2 days served with positive adjustment, which is no rule violations or no refusal to perform required or assigned duties. Just as under earned release or challenge incarceration, if they get out early, that portion of unused or unserved confinement time will be tacked on to their ES, so the total length of their imprisonment sentence will not change. There will be a process for a court veto. So, of course, we couldn't quite take it away from the judges. This is largely going to be something that is going to be determined by Department of Corrections, but within 90 days of release to ES, so they take their confinement time, they subtract their PAT, right, their positive adjustment time, they get a kick-out date to ES, and then within 90 days of that, DOC is going to notify the sentencing court and say, hey, this person's about to get out. Why don't you bring him back to court and tell him no? No, I mean, that's certainly going to be one possibility. The court then has 30 days to decide whether to hold a hearing, and then they have to issue a decision within 60 days, so it doesn't delay the release. And then what the court will consider is their conduct in the institution. Okay, that's good because that's been positive. The risk to reoffend, which hopefully will be good for these people because they're in the, they've already been through the risk assessment instrument. And then, of course, they'll consider the nature of the offense, which, boy, that's always a good thing for us, right? And then the court can either accept the DOC determination or they can give them a little more time, up to, but not obviously going beyond the initial confinement time, right? So they can say, I don't want you to get out at 1/3 cut, but I will let you out at 1/4 cut off your initial confinement time, as long as the time ordered does not concede the confinement portion of the original sentence. Okay, so that's Category 1. Category 2, these are the high-risk F through I felonies and violent F through I felonies. They get 1 day out for every 3 days served. But they have another hoop to go through. They have to first petition to the Earned Release Review Commission, which is the parole board, renamed. So this is going to be, in some senses, like trying to get out on parole, only it's going to be getting out on parole for potentially a 25% time cut. If the Earned Release Review Commission approves, then they notify the court, and the court, again, has a potential veto. So, this is going to be 2 hoops to get through this process if you're in this Category 2. Category 3 is going to be one day for every 5.7 days served, which turns out to be 85% of the sentence. And then they have the same procedure as Category 2. Apply to the Earned Release Review Commission when you reach that point at which your confinement, subtracting your positive adjustment time, brings you up for a potential to be released. And then if they approve, the court gets the possibility of the veto. This will apply to all TIS inmates, okay? TIS 1, TIS 2, not new law inmates, which is, people who've been in for a long time at this point, unless they're people who've, been sitting out on a warrant for a long time and just get picked up and prosecuted. Certainly there's people like that in the news lately. But it only is going to take into consideration positive behavior after 10/1 of 09. So you got like 5 more days to raise havoc in the prison. And then you want to start being positive. No more negative behavior. So that's positive adjustment time.